These foreign companies come in a clutch of different personalities. The holding company is A in USA. Its Asia regional head is B, located somewhere in Asia. Its India company is C. And when a tender is floated, the bid is by an SPV, which is D. My lord must have had hundreds of cases like that. Now, they are all really, not in every case, because they are part of a large group, it doesn't pierce the veil and have a group companies doctrine. Not that I'm saying that. Now, at the documentation at the beginning of the negotiation, and thereafter, more importantly, in the performance, the SPV may be a shell company. Frequently, it outsources or gets it implemented by the previous company C. The negotiation is entirely done by B and C. Now, your lordships may, in an appropriate case, have necessity to say, look, all of these, well, if a dispute starts and I go only against D, it's a Pyrrhic victory for anybody. Let me deal with the extracts, which cover many numbers. I can read the judgment. I've got the facts of most judgment also marked. Maybe when your lordship asks me anything specific, I'll do that. But normally, your lordship may not need to. That's the advantage of putting it down. And that's why we could give it only 9:30, because your lordship will have, of course, any facts your lordship want to know, I will certainly go to it anyway.
Dr. Singhvi,
I'm sorry.
We are at it. You described this leaving out the 2(1)H amendment.
Yes.
Incorporated.
Yes.
And saying that section 8 should be interpreted singly in order to understand what the Law Commission intended. You have described it as a red herring. Why do you say that?
Yes.
Because we are yet to hear the Solicitor General on why either it is left out deliberately or it is,
No, that was the reason behind the thing my learned friend will have access to. I have not found anything.
No, correct. Of
He
course,
will
he
have,
has to say it.
I mean it a different way. My point is not about the reason behind that. My learned friend will enlighten us, and I'd like to enlighten us. The issue in 2(1)H, your lordship, that's coming in my section E, but let me just explain it here. In the light of paragraph 15 and 16. Party means a party to an arbitration agreement.
Yes.
Textually as it is, it does not mean party means a signatory to the agreement. Textually. Facially. Party here, when read not only with 8, but with the general common law which your lordship has adumbrated. In appropriate cases, where justice so demands on my 16 principles, will include the group party. So 2(1)H is not anathema. What I am saying in 1516 is only that what your lordship finds in the full play of section 8, which is the actual text amendment. I'm not saying I'm arguing, I'm saying in the event it is argued. I've not heard Mr. Rai yet, he may not argue it. In the event it is suggested that your lordship should whittle down the scope and meaning of 8, because 2H was not correspondingly amended. That would be a wrong approach to interpretation. That's the only purpose of my saying. So I'm very grateful for the query. So let me summarize. 1. Common law establishes a group doctrine which your lordships has no particular reason, in my humble submission, to dilute or nullify. Subject to my lord's decision ultimately. That's my issue B. I've given 16 principles. Second, common law to some extent was inserted into 8. I mean, they don't use the word group doctrine, but to some extent, right? And it had a law commission, it had a history before of Chloro, it had 45 and 8, all that stuff your lordship knows. So second point is that insertion is a recognition by statute of some part, some scope of the group doctrine. Third, question arises that insertion is faulty, incomplete, should be read down by your lordships, whittled down, or reduced to vanishing point, because the legislation never amended correspondingly to 1H. Answer is no from my side. Fourth, why is it no? It is no because firstly 2(1)H itself is consistent with an expanded meaning of a group party where the case arises. It is not to be limited to signatory. Fifth, the second reason why 21H will not be a hindrance to your lordships, if it is so, I don't know which way the direction the argument will go, would not be a hindrance also because 21H, your lordship may have amended, may not have. My learned friend will give us the reason why I have not found anything in the Trago Preparatoire. It can't affect the direct legislative intent to insert 45 into it. So that's the fifth point about interpretation. Your lordship's approach to interpretation should not be, unless compelled to do so, that your lordship whittles down X by reference to non-amendment of Y.
So once section 8 has come in, you interpret section 8 on its own.
I'm very grateful. Words. Own plus more fortified by 246, Law Commission and Chloro. Chloro, that para I read yesterday, made a clear distinction. It said 45 has this language. 8 does not. Para 59. 69. And therefore that led the Law Commission also, then led to, whatever the reason, they said, look, the code is appointed on 45, let's have it in 8 also.
The judgment in chloro should not have a chloroform effect.
That appears to be a potential argument which I am in advance preempting. My lord is absolutely right. A chloroforming effect on 8 because of the non-amendment of 2H would be wrong approach to interpretation. My lord is absolutely right. Chloroforming, deadening, stilling or chilling effect should not be there. I am grateful. Now the lordship comes to D. They know it. Some of these fellows, quotation the lordship will see, and then these are important. Now, your lordship has a whole development of the law. It is not a one spot of the summer or one splash, one drop in the pond. This is a consistent thing. See the way it is developed, and your lordship will see what is objection. So, chloro is intention of parties, the test I said, along with commonality of interest to bind non-signatories. All the paras are given there. Then they also put it on implied or specific consent in para 107. Now, some of these I will read, but at the moment I am only reading the extracts. I have chosen only two, otherwise it will become very long. My literature will become many pages. So I am giving you two extracts. This evolves the principle that a non-signatory party could be subjected to arbitration, provided these transactions were with a group of companies.
Oh yes, para 72. Okay, yes. Yes, thanks. Yeah. Yes.
And there was a clear intention of the parties to bind both the signatory as well as the non-signatory parties. In other words, intention is my first principle, true intent. This is my first principle, and that is the correct way. Both contract law and arbitration law, main object is to fulfill this intention of parties. You have to say it 100 times. Is a very significant feature which must be established before the scope of arbitration can be said to include the signatory as well as the non-signatory parties. A non-signatory or third party could be subjected to arbitration without their prior consent. But this would be only in exceptional cases. Now, why should a lordship have to change this emphasis or even the contours and guidelines? Kindly pause here, I am saying something different. The lordship has laid down a certain law. My lordship has already cribbed and confined it by such paragraphs. It is not that in every case we just jump up and say group, and a lordship accepts group. So there is sufficient inbuilt safeguards. The court will examine these exceptions from the touchstone of direct relationship to the party signatory to the arbitration agreement, direct commonality of the subject matter, and the agreement between the parties being a composite transaction. These are some of my guidelines, my 16 guidelines. These are some of the criteria. Now, your lordship cannot be asked to crib and confine it in a manner that your lordship is to anticipate all future situations and bring in rigidity and non-flexibility. That's not possible for lordships. Commercial matters have very, very different contours every future case. Charan. Well, I had the occasion to appear in Charan. My lord heard it. That was a little strange, in fact. You may not remember this.
This was actually a very strange case, because he had assumed the obligation clearly.
Not only that, I appeared for the losing party whose immediate relation had lost the arbitration award up to the Supreme Court.
Right.
He set up a proxy to challenge the same award all over again. I was appearing for that proxy. Your Lordship found him with a proxy. Your Lordship found him with a proxy. You were denying it's a proxy, but your Lordship found him with a proxy. So that really turns on that. Of course, we were denying it's a proxy. Your Lordship found in the matter of fact. And that's how your Lordship clears the way. The original award was lost up to the Supreme Court. The new fellow started the ladder all over again. So, here, Group Companies Doctrine applied to pierce the veil. Doctrine of companies is akin to principles of agency or implied consent. Now, C, D.2c. In Charan, so the Lordships relied on bond. The doctrine provides that a non-signatory group may be bound by an arbitration agreement where a group of companies exists and the parties have engaged in conduct. This is where the principal comes in, such as negotiation or performance of the relevant contract, or made statements indicating the intention assessed objectively and in good faith that the non-signatory be bound and benefited by the relevant contracts. While the alter ego principle is a rule of law which disregards the effects of incorporation or separate legal personality, in contrast, the Group of Companies Doctrine is means of identifying the intentions of parties and does not disturb the legal personality of the entities in question. So, my Lord makes a distinction which is conceptual. In other words, the Group Companies Doctrine is akin to principles of agency or implied consent, whereby the corporate affiliations amongst distinct legal entities provide the foundation for concluding that they were intended to be parties to an agreement, notwithstanding their formal status as non-signatories. I'll just pause here. Take an actual situation, we do it every day on this side of the bar, and a lot of hear many of those fact situations on that side. Whereas foreign companies come in a clutch of different personalities. The holding company is A in USA. Its Asia regional head is B, located somewhere in Asia. Its India company is C. And when a tender is floated, the bid is by an SPV, which is D. My Lord must have had hundreds of cases like that. Now, they are all really, now, in every case, because they are part of a large group, it doesn't pierce the veil and have a group companies doctrine. Not that I'm saying that. Now, at the documentation at the beginning of the negotiation, and thereafter, more importantly, in the performance, the SPV may be a shell company. Frequently, it outsources or gets it implemented by the previous company C. The negotiation is entirely done by B and C. Now, your Lordships may, in an appropriate case, have necessity to say, look, all of these, well, if a dispute starts and I go only against D, it's a Pyrrhic victory for anybody. Whereas if I go against only D and I win an award, it's a Pyrrhic victory in many cases. It's a futile. Equally, it doesn't mean that a Lordship straight away goes to A. That's not the argument. But your Lordship must have play in the joints, flexibility in the joints to decide. Whether the judges ultimately decide by a feel of the case. According to me, feel of the case is the most important. There, your Lordship then goes into details. Now, the feel of the case requires justice to be done. Your Lordship is told strictly there is no doctrine, or the doctrine is so circumscribed that you will not go beyond D. That will cause injustice. That is not, and something which is not new. Your Lordship has got it 10, 12 years in India and much before that abroad. Why should your Lordship creep it, confine it more, or indeed abolish it? That's the question. In this group, your Lordships needs award not to be Pyrrhic. Well, sometimes they say that the evidence will not be there if you don't have other parties. Sometimes you say that witnesses will not be there if you don't have other parties. That flexibility has to be there. just to say, one of the arguments is that this group doctrine is only in 2 or 3 countries.
The flip side of
India,
flexibility, the flip side of flexibility is uncertainty.
No, I'm coming to that. Now, uncertainty. Suppose this same example I've given, the contract makes it clear in those 2 crystal clear clauses of great comprehensiveness that the parties from the inception know that this is being negotiated and performed by D or rather by C, but the SPV is D. And under no circumstances shall there be any liability, any suability, any involvement of C. That will be an important exculpatory circumstance, even there is not binding on a lot. It will be an important clue to the intention of parties. It's the intention of parties the lordship is searching for. That intention may come from a letter. What is referred to as uncertainty is also going to play in the joints.
Suppose the conduct of the parties are such, and yet they have a letter written by the principal A that we are nothing to do with this contract. But then they have conducted themselves in a manner which would suggest that they have actively participated.
Exactly.
Then that letter, would that be a defense?
No, that's the point I'm making. It is all in the common hodgepodge of your lordships gleaning the intention. In the common hodgepodge, your lordship finds that everything is done from breach, from performance, from negotiation, from implementation by X. But X has written a letter, look, I'm out. I'm not liable. No. Your lordship will go by the overall conduct of the case, that one letter will not escalate. However, if from the inception there are repeated letters saying that, look, this is the position we have put not 1 but 2 companies, then it will be one of the clues to intention, not dispositive. The answer by Lord Roy is very not dispositive, not binding, but it will be one of the clues to intention of the parties, which is paramount. Ultimately, the reality, the real point of this doctrine is the reality to do justice has to be seen, not the formality. And your lordships should not, according to me, worry or be anxious about the fact that your lordships can never in any principle anticipate all the myriad cases or situations. Within the existing 16 principles, or any more principle your lordship may add, how is it possible that somebody will get injustice because your lordship has ample principles here?